Welcome to Monthly Mets with Keith Metz.
Welcome to the Monthly Mets with Keith Metz, founder of the Metz Law Firm in North Carolina. Keith focuses on DWI traffic violations and misdemeanor criminal defense, helping people to navigate charges that can affect their license, their record, and their future. I'm Lisa Mosbey, your host, and today we're talking about what happens when you're charged with a misdemeanor in North Carolina and whether that charge can ever be cleared from your record. Keith, thank you for joining me today. This is a serious subject that we're getting into today.
It is. I'm excited to talk about it, Lisa.
Yeah. What does that actually mean to be charged with a misdemeanor in North Carolina, and how serious can it be?
So we have to separate misdemeanors from felonies, of course. Misdemeanors are everything that's not a felony. And North Carolina misdemeanors are traffic matters. They are DWIs. They are lower level drug possession charges. These are larcenies or thefts, assaults, and that's pretty much the general roundabout for what misdemeanors are. They're your lower level charges. There are certain misdemeanors that, depending upon the circumstances, could also be a felony. For instance, larceny, if the amount stolen is in excess of $1,000, it is a felony. But if it's under that, it's a misdemeanor. So there are some that will extend out to felonies. But they are still, important because you can still do jail time for misdemeanors. Not nearly as long as for a felony, but you can absolutely still go to jail for a misdemeanor.
So there is some seriousness there. I'm curious what happens between the charge and the first court date in district court.
So this also depends on what you've been charged with. For instance, if you were charged with, let's say, speeding, like 90 to 65 with a reckless driving, both of those, by the way, are in fact misdemeanors. The speed is a class 3, which is the lowest level misdemeanor that we have. The reckless driving is a class 2, which is not the lowest. It's just one notch above that speeding. So if you're charged with something like that, simple speeding ticket, still a misdemeanor. Officer's just going to give you your citation, which is going to give you a date to appear in court, and that's going to be that. On the more difficult end of that, we're dealing with, you're going to be arrested. DWIs, for instance, or another one that comes immediately to mind is assault on a female, which is a class A1 misdemeanor. It's the highest level misdemeanor that we have. With charges like that, you will be arrested. You will have to make bond, and you'll be given the opportunity to bond out of jail. Assuming you do bond out, you will be given a court date for what we call a first appearance court date.
And Keith, I hear that there's different levels of misdemeanors, 1, 2, and 3 you'd mentioned. Are all of those categories, or each of those categories, all misdemeanors within that category, are they treated the same, or are there important differences between classes and potential penalties?
The differences are only within the penalties. The penalties meaning, what does jail time look like? What form of punishment can the court give you at certain levels? So, for instance, for a class 3 misdemeanor, that's going to be what we call community punishment. So let's say you're a first-time offender, you've got no prior misdemeanors, and you were charged with speeding, and you're convicted of that. You're not going to go to jail for something like that. It's just going to be, your punishment is going to be what we call community punishment, which is, typically speaking, court costs and fines, but sometimes can also include something like community service.
And for someone who's never been in court before, what should they expect when they walk into North Carolina District Courtroom?
So hurry up and wait. North Carolina, you're gonna wait a long time, and it doesn't seem to matter if you have a lawyer. Sometimes, depending upon the county, having a lawyer gets you out of court quicker. For instance, Gaston County, they'll take attorneys' cases first. Cabarrus County is the other way around. They take attorney cases later on in the morning. Nevertheless, regardless of what county you're in, you're just gonna wait. That's what the process is hurry up and wait. That's what you should be expecting, is to just clear the day, especially if your case is scheduled for a trial. Trials for misdemeanors, by the way, are all set in district court. So felonies are in superior court, misdemeanors are in district court. District court trials do not have a special time slot. So For instance, felonies, you might know, hey, we're starting this trial at 2 o'clock on Tuesday. You don't know that in district court. You walk in, and if your case is scheduled for trial, they'll get to it when they get to it. Sometimes they don't get to it. Sometimes it's got to be continued to another date before you can have your trial. So you should expect to wait, especially if your case is going to be for a trial. You should expect to clear your day, and be ready to have a trial at 9 o'clock or at 4 o'clock in the afternoon. So I think that's what the biggest thing that you're looking at. Of course, other expectations might be if you're going to be looking at jail time, if you're pleading guilty, or if you take the case to a trial and lose, you're found guilty. What are your expectations? Are you going to be taken into custody right then and there? These are things that vary from case to case and are something that you should probably discuss with your lawyer.
What are the mistakes that people make after being charged with a misdemeanor that can hurt their case?
I think the biggest thing is really talking about things online. The current society right now, just sort of the way we are, we have to put everything on social media. We put everything on blast. Um, the police have access to social media, and they can absolutely, and they do get warrants to search your social media accounts, your Facebook, your Instagram, your TikTok, whatever. Police can see that. So anything that you're posting online, even if you think you're only posting to, you're just your friends and family, police can still get access to that. So if you are charged with a crime, I'm going to tell you what every lawyer tells people, and that is to shut up. Say nothing. Uh, Tell only your lawyer, and do not blab about anything on any form of social media. Don't put it out there, because it can and will come back to bite you.
Even those photos, those accident photos at the scene where people say I was just in an accident, those can hurt you?
Those can certainly hurt you. I think those are going to be more of a civil aspect, but I would still recommend not sharing them with anyone until you hire a lawyer, and certainly share them with your lawyer. And if your lawyer says if it's okay to put them on social media if you really want to, I think that's fine. But I would refrain from doing that until a lawyer professional tells you otherwise.
What usually determines whether a misdemeanor charge can be reduced or dismissed?
Several different factors. The first is going to be what your criminal history, criminal record looks like. Obviously, if you're a first time offender, it goes a long way in getting, if not the charge dismissed, then at least reduced to something, or a plea that gives you something that you can work with. Uh, if you have a criminal history, it makes things more difficult. Not necessarily impossible. Depends on the county, depends on the DA, depends on the charge. But obviously, having a larger criminal history is going to make things more difficult for negotiating things. But certainly also what county you're in. For instance, Cabarrus County really does not negotiate like on anything. Uh, Typically speaking, their offers are usually plea or trial. Occasionally, you can get some sort of a plea offer where they'll agree to reduce the charge, but generally it's either plead guilty as charged or plead not guilty and take the case for trial. That's different in Mecklenburg, and it's different in Gaston County. So this varies from county to county. Of course, it also is going to vary on what type of misdemeanor that you've been charged with as well. The DA's offices, regardless of the county, will refuse to bend on and will refuse to amend. For instance, this one's not even a misdemeanor. Immediately comes to mind. It's actually an infraction. Infractions, by the way, are not criminal in nature. They are literally just a fine. They might go on a driving record. They will not appear in a criminal record search. But the charge is passing an emergency vehicle, which in North Carolina is an infraction. However, the DA's offices in every county that I practice in Gaston, Union, and Cabarrus, and in Mecklenburg, they all take this very seriously. So even at the end of the day, you're not looking at jail time. You're just looking at maybe certainly some increased insurance premiums and some court costs. They won't reduce it. So if that is true for something like an infraction, it is equally true for certain misdemeanors as well. Sometimes it doesn't matter if it's your first offense; they simply won't agree to reduce it.
In my first question, I asked about the seriousness of being convicted of a misdemeanor, and you said jail time is possible depending on what the misdemeanor is. How can these things affect employment, background checks, or future opportunities?
I get this question a lot, and it's always a difficult question to answer. And the reason is because I am not your employer. Um, It can absolutely impact background checks if you're convicted of various misdemeanors. Certainly, it's going to go on a background check, but it also sometimes depends on what type of background check your employer is using. For instance, if you don't live in the state of North Carolina, it might not show up in, say, a Florida criminal record search. If they're only searching for, if you're employed in Florida and your employer is only searching for Florida criminal records, a conviction in North Carolina might not show up. However, if the search is more broad, and generally speaking, some employers will use like third party criminal record searches, it might show up in a more broad search. The problem with the third party searches that a lot of these employers are using is that they will show up absolutely ridiculous things. There have been, for instance, simple speeding tickets that I have gotten reduced to an improper equipment, which is going to be the best sort of thing that we can handle on a speeding ticket. And instead of the ultimate conviction of the improper equipment showing up, these third party search bots and search engines will find the original charge and pretend the charge is the final outcome in the conviction. So that sometimes can create issues with employers. um, the best thing that I can tell you in this regard is sometimes it's better to just be honest and upfront with your employer and explain what you've been charged with and what's going on. We make it a policy here at the Metz Law Firm that if a client wants and asks for a letter for their employer explaining the process about what they've been charged with, what it means for them, and sometimes what deals I think I can get from the DA, what we can get this reduced to, I'm always happy to write and sign off on that letter.
Do people sometimes assume a misdemeanor will automatically disappear from their record later when it actually won't?
I think this is more so true with traffic matters. I think a lot of people tend to believe, and they believe correctly, that if they're convicted of something, it's going to be on their record permanently. The action to remove it from a criminal record is called an expunction or expungement. They're exactly the same thing. Their terms are used synonymously. And our expungement laws in North Carolina are very, very complicated and very complex. There are certain criminal convictions that we can get expunged in North Carolina. There are certain criminal convictions that we cannot get expunged. It depends on the conviction. Other matters go into this as well. For instance, do you have more than one conviction? If so, it's probably you're probably ineligible for an expungement, unless it's like a traffic matter. Um, Speeding matters are a different story. For instance, if like you've been convicted of um, theft, larceny, and you've also got a speeding conviction in your background, no one really cares about the speeding conviction. So we're just sort of looking at the larceny conviction. Also, timeliness is something else as well. Generally speaking, you have to wait anywhere between 3 to 5 years before you can get a misdemeanor expunged. So it is going to sit on your record for some period of time before you're going to be eligible for that. Convictions of crimes where violence is an element within the crime, for instance, anything with an assault or any subcategory of assault on a police officer, simple assault, anything like that, those will never be able to get expunged. I shouldn't say never. Currently, they're not able to get expunged. The law changes on expungements all the time. DWI, for instance, is another matter that cannot be expunged in the state of North Carolina. So the answer to your question is I don't think that people necessarily believe that it's going to just be removed automatically. But I do think there are certain misunderstandings about expungements and misconceptions about how expungements work. People tend to think that I can just get it expunged later. That might be true, but it also might not be true. Like I said before, North Carolina's expungements laws are very nuanced.
You'd mentioned when there's a background check that these third-party companies may see the original charge, but it doesn't always end there, which makes me want to ask the question, can a misdemeanor charge sometimes be resolved much differently than it first appears at the time of the arrest? Can you talk about that?
Yes, I can. So, it can be resolved differently. I think this question is probably better phrased in the form of a felony, because what happens sometimes is the original charge that somebody might be charged with something is originally charged as a felony. And then after the DAs look at it, maybe they realize they don't have enough evidence to prosecute it on a felony. They don't necessarily dismiss it, but they will reduce it down to a misdemeanor version of the same charge. And then it's left to the defendant or the defendant's attorney to try and either take that case to a trial to beat that, or to negotiate some better plea offer with the DA in district court where misdemeanors are at. But if you're just charged with a misdemeanor from start to finish, generally speaking, there's nothing unusual that happens from it, or there's nothing that really alters with it unless you get some sort of plea deal. The plea deal for a misdemeanor is going to be you're charged with thing X, and the DA is agreeing to reduce it down to thing Y. So that's sort of how the plea deals work. So the starting charge becomes and is amended to, when you're convicted, something else entirely. That sort of is how the misdemeanors can change a little bit.
Keith, I want to thank you for your insights today. This guidance through this process has really helped clear things up.
Thank you, Lisa.
That's it for today's episode of the Monthly Metz. If you'd like to learn more about Keith Metz and his work at the Metz Law Firm, visit keithmetzlaw.com. Thank you so much for listening, and don't forget to subscribe, leave a review, share this episode with someone who might need it, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.